Okay, hello, Government 150 at Sacramento State, or maybe one of my other classes that you might be taking. Okay, this is the second Supreme Court lecture. Remember, the first lecture covered just a bunch of the basics. Now, in this lecture, we're going to talk about this is actually kind of fun, some of the fun stuff in judicial interpretation. Now, it might sound easy to you, like, oh, well, come on, how hard is it? Like, the Constitution says certain things and just do them, right? Well, it's not that long of a document. It says a decent amount of things, but it's a little bit unclear. It's actually quite unclear in many respects as far as how it applies to many of the problems and issues that face us as a society today. Okay. Now, the truth is, in most of the easy cases, the law, the Constitution, and whatever law we have is quite clear. And, you can just sit there and apply it. It's really easy. So, did you steal the TV from the store? No, I didn't. Well, we have the camera footage. There's no question here. The law is quite clear. There you go. You're going to jail. But the Supreme Court gets all the hard cases. So all the places when the law isn't clear, when the Constitution can be read in different ways, all of those end up at the Supreme Court, okay? And because of those unclarities, it means that there's actually, when you're at the Supreme Court level, a lot of leeway for them to put their own opinions into it, okay? There are at least about 5 different key things that go into judicial interpretation, okay? First, you have the text of the Constitution itself. What does it say? That's the beginning of all of constitutional interpretation, really. Then you have what's called precedent, or in Latin, stare decisis. All that means is before we make a new ruling, we're going to look at how judges have ruled on similar cases in the past, okay? Now, again, that's not always super easy because lots of times the Supreme Court especially is looking at something because the former precedent is a bit unclear, right? And so, they're not really sure. And so they're going to be looking at that. But they will say, okay, there was this former case we had, we ruled this way, this case is a little bit different, but, does it apply? Yes, no, maybe, right? So precedent. And precedent is huge. I mean, precedent is second only to the Constitution in judicial interpretation, and or positive law. So laws passed by Congress actually deserve to be in here. Changing political opinions and norms. So, people's opinions when they change on something like gay marriage. Justices are people, their opinions start to change. And when you look at 30, 50, 70-year time frames, people's changing norms, opinions and norms are an important factor in judicial interpretation. Other things that get looked at are political consequences. What will happen if we rule this way? Some judges care more about that than others. Some care more about opinion and norms than others, and some care more about precedent than others, okay? And then finally, judicial philosophy, which gives a way to kind of rank all of these different variables at hand. When we say judicial philosophy, it sounds great. It sounds like, oh, the Supreme Court is has these highfalutin principles and they're really sticking to them. They're like the high priests of the law. And so, we're certain that we feel like we're certain that they're really living, like making decisions based on principle alone. The truth is that's probably the exception and not the rule. Judicial philosophy matters, don't get me wrong. Most judges, including Supreme Court justices, engage in what's called motivated reasoning. Motivated reasoning is deciding the answer you want and then finding justifications for it. So most of them, and this is how most people make up their minds on a daily basis, we want something, then we come up with reasons to justify doing that thing, rather than the other way around, where you have a set of reasons and you say, what action fits my reasons, right? And then the other thing to keep in mind is there's enough legal principles and different approaches and precedent out there, especially at the Supreme Court level, to justify almost any decision, right? So it's important to keep in mind that while these important ideological distinctions matter, justices are not particularly bound by their own principles in many of these cases, okay? So you see them say, this, and then they make a ruling. You're like, that has nothing to do with what you just said, right? Happens all the time, okay? And part of that is kind of baked into the American legal system. We use what's called the adversarial system, which means lawyers have ethical obligations to present the best argument they can for their client, even if the lawyer knows he or she or the client is guilty, okay? That's not true in all legal systems. Like in some legal systems, the two lawyers have a mutual obligation to try to discover truth. And then secondly, they're trying to defend their client, right? Like lawyers are mostly usually there to defend you, unless you're in North Korea. It's not so good, but happily we're not in North Korea, right? So lawyers come up, I mean, this is the province of Law and Order, right? Like these lawyer shows drive me nuts because they act like they're so high and mighty, and all they do is spend their time trying to find loopholes in the law and engaging in bad faith argumentation and trying to manipulate each other. I mean, I'd rather that they just be honest and they're all Saul Goodman from Better Call Saul, which is the prequel to Breaking Bad, which this is coronavirus time, and so I've made it through most of that show over the last. I actually started before the coronavirus hit, but that's been the show of this semester for me. But at least Saul Goodman, he's like pretty honest. He's like, yeah, I'm a little shady. I'm like, okay, great. Like as far as I can tell, most lawyers are basically Saul Goodmans, right? But this type of adversarial system is also clearly motivated reasoning as well. Now, just to be clear, there's limits, this is what I like about the Better Call Saul shows. Excuse me, he doesn't seem to have a lot of ethical problems with the things he does, but his girlfriend does, and it kind of comes out that, a lot of these things are pretty problematic, and she's not sure if she's okay with it, and, that kind of stuff. But the adversarial system is also motivated reasoning. So it's really kind of like baked into our legal system, okay? And if I ever wasn't being recorded or putting something on the internet, I might share a story or two of you about jury selection. They never select me. I don't really want to be selected, but, I've been called a couple times and had to sit through some cases, and they get to me and they're like, oh, you're excused. I'm like, cool, go home. But I've seen lawyers do, even just in jury selection, some things that I personally find to be, high levels of gamesmanship, right? And that's part of trial law, and that's fine. I want the truth. You can't handle the truth, like that kind of thing. But here's the deal. I'm a trained philosopher, and philosophers think that people are engaged in a mutual endeavor to try to come up with some kind of truth or something approximating it, right? I'm skeptical. I don't know about absolute truth, but there's some things we're pretty sure about, some things we're not so sure about, and philosophy is the exercise of trying to separate those two things out. Well, lawyers try to conflate those two things as part of motivated reasoning in order to get their clients off the hook, right? And so do justices sometimes. I mean, some of the actual rulings that they write are case studies in tortured logic. Tortured meaning you're harming the principles of logic when you're doing this. But what? They're also political creatures. They decided what they wanted to rule, and then they go and they try to find the legal principle that will justify that. Okay, so the first part of judicial interpretation I want to talk about is a little less actually about interpreting. It's more about of the interpreter, right? We have this really distinction, this very basic way of thinking about how should a Supreme Court justice go about deciding a case? Should they be restrained or activist? Okay, judicial restraint is the opinion that the Supreme Court should try to stay out of politics as much as possible. So they're lawyers, they're not politicians, they're not elected. They should try to make rulings that we call narrow. A narrow ruling is a thin ruling that not a lot happens on it, right? So a narrow ruling that sticks as close to precedent as possible and really tries not to rock the boat. And in that case, they're also having a large amount of deference to the political branches of government. Unless something's pretty clearly wrong, a violation of the Constitution, we're not going to overturn it, right? We want to have good constitutional grounding for overturning things. On the other hand, judicial activism, it's the view that it is appropriate for the Supreme Court to take political stands on matters of public importance. And sometimes you should be activist. I mean, I'm more of a restrainer personally, and I'm sure it'll come out in class some of the reasons why. But judicial activism is definitely not always wrong, not by any means. And there's some rulings that I absolutely would have made that were activist rulings, but most of them I wouldn't, right? So we say in this term, the contrast to narrow is broad rulings that change a lot of precedent, or that create a big new precedent, or that have a big, and also rulings that tend to more likely have lots of political consequences, okay? So judicial restraint, you're restraining yourself, right? Judicial activism, you're active, you're out there, you're doing things. When justices are making decisions, there's some tools of the trade, if you will, for how they're doing. There's judicial principles, sometimes also called doctrines, okay? So judicial principles have built up through time. They're actually part of precedent, and they're kind of shorthands for certain types of precedent, okay? So in criminal cases, for example, burden of proof beyond a reasonable doubt is a principle. It's a judicial principle. There's a lot of these, okay? So we're not going to have a complete handle on all of them. I'm just trying to kind of wrap your brain around a few key ones, sort of give you some interesting pieces to think about here. Sovereign immunity is another legal principle. In this case, meaning that governments, which are sovereign, okay, so sovereign means self-governing, no one outside is allowed to tell you what to do. Governments in most cases cannot be sued for crimes. There are some exceptions here, okay? But like, for example, when the human rights commissions, which are kind of derived from the same stuff as the UN and all of that, when they start trying people for crimes against humanity, people like Slobodan Milosevic, who in Bosnia-Herzegovina was engaging in just straight up ethnic cleansing, that's death squads and murder on a state level. He said, you're trying me. I have sovereign immunity. I did these things as the person of the government of Bosnia-Herzegovina. You can't try me on that. I'm immune. Well, we don't care as much about that anymore. And we said, too bad, you're guilty. Okay. But still, sovereign immunity is quite strong. And it's actually derived from the king's right to be above the law through European. So there's just a few more principles that I want to give you to kind of think about. One of the more famous ones, well, that you definitely haven't heard of, but that's actually quite important, is what's called the non-delegation doctrine. In the Constitution, it gives Congress the right to do certain things, regulate trade and some other things like that. Well, it says Congress gets to do this, but it doesn't say whether Congress can have somebody else do it for them. Delegate, right? In this class, if you delegate writing your paper to somebody, you're cheating. that's clearly a violation of ethical standards in this field. But that's very rare. That's actually more the exception than the rule. In most cases, it's perfectly acceptable to delegate work. You're working as a team. My wife works in an office. Her boss gives her a task. She delegates it to somebody else in the office. She also manages that person to make sure that person is doing the work effectively and according to the standards that her boss will like. She's ultimately responsible for that work being done. So she's there like watching and making sure that that person does that work well. She helps them get it done. But if anything goes wrong, she's the one who's going to get in trouble. And she says, well, I delegated this. Her boss didn't say, look, that's fine, but you're still ultimately responsible. Okay, so here's the question. Can Congress delegate things that the Constitution says they're supposed to do to other people to do them, i.e. the executive branch? Today, the answer is yes. The non-delegation doctrine is no longer applied by courts, but 100 years ago, it was. It was a major part of what the Lochner Court was doing when they were overturning lots of progressive era and New Deal legislation, okay? Equal protection, this comes from the 14th Amendment, equal protection of the laws. That's a doctrine, okay? Plain view doctrine versus warrantless searches, okay? So, Fourth Amendment says you have to have a warrant for a search, okay? But if you open the door and the cop sees illegal activity, you just showed it to him, literally, okay? And that's exempt. That's called the plain view doctrine, okay? Or if he can see your windows open, or he can hear, oh, someone's being murdered in that house. Okay, I don't need to go get a warrant. I now have probable cause. From plain view, in this case of my ears, I can tell that there's a problem here. I'm going to go fix the problem, right? I've done some searching to try to get like a really nice comprehensive list. It's not really there. I found this okay one from Wikipedia. So, you could follow up with that if you wanted to. Okay, so there's all these very specific principles, but one of the biggest ones and kind of just a general guiding idea is the principle of precedent. And in fact, all those other principles are all built up through precedent. Some of them have been done kind of by positive law as well. So there's kind of this dynamic flow back and forth between the judiciary and the Congress. And Congress does stuff and the judiciary has to listen to it. But then sometimes the judiciary says you're not allowed to do that. Congress sometimes tries to fix it, right? Things like that. One of the legacies given to the American legal system from the British is common law use of precedent. Common law was the accumulation of legal rulings going back to feudal times, all the way back to feudalism, and new rulings were supposed to be based off the collection of previous rulings or precedent. Britain actually has no official constitution, but instead just a collection of rulings and key documents such as the Magna Carta that serve as a set of foundational laws. So in a way, Britain's entire constitution is basically just precedent. They never sat down and said, we're writing a constitution now. There was a couple times where they came a little bit close. Magna Carta was, king's not going to do these certain things. After the Glorious Revolution, which I talked about in my presidential lecture, a Bill of Rights was passed. King's not going to do certain things. Individuals have these certain rights, that kind of stuff. But there's no single document in Britain. And so when new issues come to light, they are ruled on by trying to extend or find legal principles that apply, and then the new ruling goes into the bank of precedent. Okay? So, little new things come up. The law hasn't made a ruling on this specific way that this happened. Okay, now we're going to have to look at it. And we'll do some examples at the end of class. So legal interpretation in the United States uses a lot of precedent still, but not as much as Britain, because if you can determine what the Constitution says and what it means, you don't need precedent, right? So we still have it. It's still very important. But in some cases, we've deviated from what the Constitution probably really says. We think we didn't, but we probably did. In cases like that, you have a pretty strong argument to overturn precedent, okay? But we still use it a whole lot, especially where the Constitution is unclear, and then especially in the lower courts. And lower courts can actually set precedent as well. They say, here's the previous rulings. This one's a little bit different. It should be ruled this way. And if it's appealed, then the precedent could be changed, not set, or extended, or whatever. But if a lower court ruling establishes a precedent, it's appealed but turned down, it's denied, nope, it was a correct ruling, or it goes to the Supreme Court, but the Supreme Court refuses to take the case, that means that whatever happened at that lower court will stand. Okay, so that's the last word. No, it's not going higher. This ruling will stand. The Supreme Court can follow or not follow precedent. They get to choose. Frequently, it's unclear which precedent applies, and the court has to make a choice, right? This is what I was saying at the beginning of the lecture. There's so many different legal principles out there, so many different ways of constructing a ruling, that it gives, and especially in these big cases that are tough cases, all of that choice gives the Supreme Court a lot of leeway for how they're going to do something. And the current Supreme Court is saying, what's such a big deal about precedent? Maybe we should fix some things. And so they're signaling that they're going to be, it seems to be signaling that they're going to be a little bit activisty, okay? Remember this Latin word stare decisis, that means to stand by things decided. Okay, and then the third element of judicial interpretation involves the construction, these are also part of precedent, of certain types of legal tests to try to determine, well, in this case, is it a problem or not, okay? There's a ton of tests, not as many as different doctrines, happily, but there's a ton of tests. Like, so for example, the clear and present danger test is a limit on free speech. Shouting fire in a crowded theater constitutes a clear and present danger. Therefore, this type of speech is not constitutionally protected. Okay? So if you have other cases, other similar problems, no one's thought of it yet, but you're on a boat and someone screams the boat is sinking and it starts a panic. Well, if the boat's not sinking, that would probably fall under the clear and present danger test. You're creating a dangerous situation by saying this, right? The Lemon test. The Lemon test is a test the court uses for cases involving religion to determine if laws violate the non-establishment clause of the First Amendment, or the disestablishment clause. So there shall be no established religion, right? And the Lemon test. So, but that creates that one's convoluted test. The guy's name was Lemon, okay? It's a test. It's a test that's used. And there's also another test that's a little more relevant to what we're doing here, titled the Expectation of Privacy test. And it's used to help determine if the right to privacy is operative here. So the right to expectation of privacy test is basically, in your home, you have an expectation of privacy. That's fine. In a hotel room, you also have an expectation of privacy. But in a movie theater, you don't. In a park, you don't, right? And so do you have an expectation of privacy in this area? Okay. Just three famous tests that I wanted to kind of, again, we're just trying to sort of wrap our brains around these things. We don't have time to become actual lawyers here. We don't have any kind of time to become actual lawyers. But it can be fun, like getting getting the basics of judicial interpretation wrapped around into your brain makes a lot of sense. Then we have what we call theories or philosophies of judicial interpretation, which are going to help us rank some of these various elements that we've been looking at, right? We have Constitution, we have other positive laws that have been written down, we have precedent, we have norms and opinions, we have political consequences, and now we finally have theories or philosophies of judicial interpretation. And like I said, the philosophies help kind of put everything in order for us. Just like a scientific theory that constructs an explanation for something, and you have a series of variables that then come up with a causal explanation. A theory or philosophy of judicial interpretation is putting all these different elements of judicial interpretation in hierarchy with each other as part of the activity of then making a ruling. There's three main ones. People break them up a little bit differently sometimes, but I think for our purposes, just looking at these three main ones are the most important. And this captures most of the action we've seen at the Supreme Court over the last 40 years. So rather than getting deep into debates over what they call realism and positivism and stuff like that, that's not as necessary here. The fact that, you've heard my spiel, I've set it up. Let's go ahead and go. So originalism is a terribly important judicial philosophy. And it's really kind of where everything begins, right? So some people are mad at originalism because Scalia and Thomas were the originalists on the court. Scalia's passed away now. But I think they're wrong to be that political about it, right? Like, we need to separate out the philosophy from the partisanship. When you do that, there's actually a lot of things, believe it or not, that liberals should like about judicial originalism. I'll hit those in a second, but let's just talk about what it is. So the idea is that court cases should be decided by the text of the Constitution. Sure, makes sense, no problem. And the intent of the framers only. Like, that's the criteria. Maybe a little bit, some precedent will a little bit of precedent's going to go in there. But, they actually don't care about changing political norms and values very much. They don't care about political consequences very much. It's really just, what does the Constitution say and what are the intents of the framers? Like I said, this is where all judicial interpretation begins. So some people's complaint of it actually is like, well, duh, but like, the thing is, why are we here? Because the Constitution's unclear. So saying, oh, well, let's just use the Constitution to decide. Well, but the Constitution's unclear. That's the whole reason why we're at the Supreme Court. So how's that really helping us, right? Well, in some cases it definitely does, and in some cases it doesn't as much as they would like, right? And it's really not as easy as it sounds. The text of the Constitution frequently is ambiguous. So what does it really mean, right? So, okay, it was written by a bunch of people a long time ago. We have pretty good records. And in some cases it's quite clear, but in many other cases they didn't put judicial review in there. The Supreme Court gave it to itself. Okay, as originalists, is judicial review really in there or not? I don't know. It's ambiguous, isn't it? And we need to have a way to clean up those ambiguities. But appealing back to an ambiguous text, again, it's not going to be super helpful. Well, okay, in that case, if the text is unclear, maybe we can go to the intent of the framers of the Constitution. And, don't get me wrong, sometimes we can get to intent, but there's a couple problems with intent. The first problem is that they're all dead, right? Like, if we could channel them, mystical powers, and channel the founding fathers and have them come talk to us, well, okay, maybe we're going somewhere, right? Now, again, sometimes we can figure this out. So we can look at like minutes from the Constitutional Convention. We can look at other writings of the people who were there. There's some problems with that, even if we do that strategy, because if maybe it was left out of the Constitution for a reason, right? So in the minutes it says blah, 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 but it doesn't say that in the Constitution. Now, sometimes in the minutes it says, when we wrote this, we meant this, right? When you have that, that's a very clear stipulation of intent. Don't have that all the time, that's for sure, okay? There's a second problem with intent. Whose intent really matters here? A collectively written document ends up with ambiguous language, usually because it was collectively written. And what happens is people are bargaining and they have different things that they want, and the language is loose enough that both sides can see what they want in that language. Okay, and my guess is that this is exactly what happened with this stuff on the Supreme Court itself. Hamilton and Madison and Jay said, we really want judicial review. Somebody else said, we really don't want judicial review, and they just left it unclear. So that nobody lost. Nobody won, but nobody lost, and that's actually a pretty good compromise in a situation like that, right? And then time can sort of hash out the differences. So, I mean, that's my guess. I haven't looked at the minutes, but it would be really interesting to see that. So, okay, does the intent of Hamilton and Madison matter more than the intent of everybody else? I don't know. I mean, they were very important players there, etc. But in the end, a vote's a vote is a vote. If you really helped write the thing, that's great. Thanks for your help. But does your intent matter more than somebody else's intent? It's really hard to say, right? So we can sometimes find intent. I'm not saying we can't. I'm only saying, boy, it's really hard to find, okay? And there's some real problems with it. And then the last biggest problem with intent is that our founding fathers were keenly aware that with the passage of time, there would be new issues and problems for society to face. They wanted a document flexible enough to deal with these new issues and problems, i.e., for example, they included a process for amending the Constitution for that very reason. Am I telling you that some of their intent was for the Constitution to be flexible enough to be changed through time to deal with new problems? And the answer is absolutely yes. And there's a ton of historical literature here showing how aware they were of how passage of time meant new problems would come to light, and you need a document flexible enough to deal with that, okay? Now, was it their intent that, that doesn't maybe deal with everything, right? Some things are very clear. Maybe the Second Amendment, it seems like they're pretty clear that they wanted this to be a thing that would be there forever, right? Although that also was a compromise, okay? Like, don't forget, the Bill of Rights was a compromise to the Federalists, right? So that we're from the Federalists to the Anti-Federalists. And so many of the questions that we asked the Constitution to answer today were completely unknown to the Founding Fathers. Cell phones, gay marriage, right? Assault rifles that can shoot, whatever it is, 50 bullets a minute or whatever, they had a musket shot a bullet every 3 minutes. Like, that's about as fast as you could get, right? That's tough, right? But look, still there's some problems with intent, but originalism is the beginning of any good judicial interpretation, okay? There's absolutely no doubt about that. I'm going to do this one next. This one's being added into my lecture currently, and it's here because the new guy on the court, the new guy in town, Neil Gorsuch, describes himself as a natural law jurist. And so, we haven't seen a lot of rulings from him yet, so it'll be really interesting to see how it all shakes down. But basically the logic is that there's a higher law that positive law must reflect. I don't mean constitutional, I mean God's law maybe, or some kind of law of humanity or something like that. And this higher law, this is what Martin Luther King said when he was sent to, they said, oh, you're breaking the law. He's like, yeah, it's a BS law. Like, there's a higher law that I have to enforce, right? And this higher law can be used in a similar way as the Constitution itself as grounds for judicial review, and also then potentially overturning laws that are already there, right? Now look, just like I said, when Martin Luther King does it, okay, yeah, this seems like pretty appropriate. I think some higher law that people should be treated with dignity and respect, and not judged by the color of their skin. Like, okay, I'll go there. And in other ways, philosophically, we can absolutely do this. But Martin Luther King Jr. was not a justice on the Supreme Court. He was a social activist. And when he was tried and convicted for breaking the law, he went to jail and he served his duty, right? So I think, philosophically, the idea of a natural law doesn't really bother me so much, but I do think we should be a little bit wary at the Supreme Court level of saying, yes, there's some kind of higher law here. Look, the highest law in the land is the Constitution, okay? And disestablishment of religion also means we're not supposed to use God's law to do stuff, right? And now Neil Gorsuch's version, I don't know if he would say God's law, but actually, my feeling is that's kind of what he's going for. But I haven't done a deep study, okay? So, but legally, when we're doing judicial review and interpretation, I start to get really nervous because I can see the United States Constitution. You tell me there's some natural law out there, okay, great, show me, right? Show me the natural law. And you can't, right? It's not there, not in that way. And then I can just say, well, in my mind, natural law is a little bit different. So why aren't we ruling differently? My natural law is telling me I want to punch you in the face right now. That's the lecture I give when I'm talking about John Locke and natural law. I'm kind of a goofy, funny guy. Okay. So, that's just a few comments on natural law jurisprudence. Actually, interestingly, natural law jurisprudence is strongest in a lot of international law because you don't have as much positive laws there saying what's going on. And so then you need to turn to other sources of law, right? And so natural law, I don't want to say it's wrong or anything, but at the Supreme Court, I start to get a little bit nervous. Okay, non-originalism. They oftentimes use an analogy with a living tree that's kind of like growing to adapt to its environment, right? That's the kind of logic that they see. And they're, they always still consider text and intent. Okay, I should have that on here. But, they don't just give up on text and intent. Sometimes I have students saying, oh, well, just make stuff up. They're not just making stuff up. Trust me, they care about text and intent as well. But they're more open to including changing political opinions and norms, looking at political consequences, and just being honest if you're okay with those political consequences, okay? Brennan was one of the great proponents of this view. Sotomayor, Kagan, Ruth Bader Ginsburg, they're all kind of proponents of this view as well, okay? And they all have their own take on it, okay? But there's three criteria that non-originalism kind of add to text and intent as far as thinking about how decisions are going to be made. The first is that the Supreme Court is making public decisions. As much as they're a legal body, they're also making decisions that are going to affect the entire country, okay? And they have no choice but to make these decisions. They are the last stop. There's no one higher than them in making these decisions. So the logic here is you need to think long and hard about what you're doing, right? And maybe we did deviate from the Constitution a little bit. Maybe that's okay. Maybe we need to go back. Everything's a little different. That's all okay. But the fact that you're making public decisions and they're obligatory public decisions, like if you come to me and you ask for something about class, I have to make that decision. If I say I'm not deciding, you're like, what does that even mean? I can say no, I can say yes, I can come up with some other kind of compromise, but the decisions I make for how class runs are obligatory to me and public. They affect you, and how I rule on, sounds important, not that important, but how I rule on these things does matter, right? And they affect your lives. Well, same with the Supreme Court. The second consideration that the non-originalists like to look at is our changing norms and values. Okay, same-sex marriage, right? People started caring about that about 20 years ago. People didn't really care about it before, but they started to care. And through time, more and more states started doing gay marriage. And then the Supreme Court, had to decide, is this a constitutionally protected thing or not? And first, they made all states recognize same-sex marriages. And just 1 year later, they made all states do same-sex marriages, right? That's a huge effect that they are making from the bench. that's a non-originalist ruling, right? It's not about what the Constitution says. It's about the fact that changing social norms and values, now people think queer persons deserve equal protection of the laws. And in this case, that means getting married, okay? And then lastly, you have to look at the political consequences of a ruling. It doesn't mean you're not allowed to be activisty. Non-originalists are activists a lot of times. I don't think, particularly speaking, more or less than originalists, honestly. A lot of time people think non-originalists are more activist, but it seems quite unclear to me. So just because you call yourself an originalist, truly originalist rulings might be marginally less activist, but like I said, they're all motivated reasoning, and so when it's not, there's enough principles for them to choose from that they can be originalists and activists quite easily, right? So, but political consequences, are you okay with Brown versus Board of Education? What are the political consequences there? Well, you're pushing at segregation in the South. That's fine. I would have made that ruling. I have no problem with that ruling. But you just need to be aware that that's what you're doing, right? We're doing this. Citizens United versus Federal Election Commission. Super activist, right? Huge political consequences. I don't know if Anthony Kennedy, who was the swing vote on that one, particularly saw what the likely consequences were. But boy, that's a big, big consequence, right? Now look, there's this kind of easy assumption that people have that partisanship, attitude, and ideology kind of all overlap, but they don't at all, okay? It's easy to think, oh, well, conservative justices are restrained and originalist, while liberal ones are activist and non-originalist. As I said before, there's a lot of room for liberals to be very originalist these days, and they should really think about that. Neil Gorsuch is definitely a non-originalist. Natural law philosophy or jurisprudence is distinctly non-originalist, right? It's a little different flavor on non-originalism, but it is not originalist. Now, there was a time where this was largely true. Maybe the 90s, this was largely true, but it was more just a sort of product of the time. It was just a political happening circumstance. It wasn't any kind of like larger overarching, these things are happening for a reason, okay? And today, the conservative justices are pretty activist. They have a majority in the court, and they don't feel to me to be particularly originalist anymore. Clarence Thomas still, says originalism really matters to him, but it really doesn't feel like they're spending that much time being really hardcore originalists. And actually, so Citizens United is a great case for liberals. If they want to be originalist, you have a really strong originalist argument against Citizens United. Freedom of speech does not, it just does not mean freedom to give unlimited political contributions. It's quite clear that our founding fathers never intended for that to be in the Constitution. The evidence here of this being a non-originalist ruling is overwhelming, okay? Of it being an originalist ruling, right? Citizens United was not an originalist ruling. It was a non-originalist ruling, and it was activist, okay? But you can be non-originalist and restrained as well, right? You can just say, okay, these are the principles I'm using, and I'm engaging here in a lot of deference, so making a very narrow ruling, right? I'm trying to make my ruling small. Well, that's being non-originalist and also restrained. So you can do that as well. I want to take a look at a very famous non-originalist ruling, but the whole idea here is like originalism and non-originalism are actually a lot closer together than it seems. People put them in this big opposition, and I just have a hard time seeing that much of an opposition between them. I feel like maybe even all of this stuff is actually a little more just about politics than it is genuine judicial philosophy, but I'm not 100% sure about that. But anyways, so it's 1965, and a case comes before the Supreme Court. Do women, or does a woman, have a right to medically accurate information about birth control in consultation with a medical professional, i.e. her doctor? Do you have the right for your doctor to tell you true facts about how birth control works? I'm not even talking access to condoms. I'm just saying, can your doctor tell you that condoms exist and that they can prevent pregnancy? Right? And states for a long time had banned sharing of information about contraception and contraception itself. And so, yeah, there was a black market in condoms. Of course there was, because people still want to, right, have fun, and they do want to try to have some family planning, okay? Believe it or not, the origin of Planned Parenthood, when it was first founded, it was called the American Birth Control League. The origin of Planned Parenthood was with a woman by the name of Margaret Sanger, who would periodically get arrested for hanging out on the streets of New York and handing out pamphlets explaining how birth control worked. The cops would come, throw her in jail for a couple days, but she was kind of a big believer in family planning, and women would come to her and say, I've already got 4 kids, I don't want another one, et cetera, et cetera. What can I do? And she would sort of try to talk them through it. Okay. Well, the Constitution doesn't say anything about anything on this one, right? I mean, it seems like you should have that right. I'll go that far, right? Like, wow, I don't even have a right to accurate information about birth control, much less birth control itself, but just accurate information. So what are you supposed to do? Well, this was the court's logic, okay? The court said, look, if you take the Constitution and the Bill of Rights and you kind of shine a light through them, okay, you can see that there's these different themes from different parts of the Constitution, the Bill of Rights, and they kind of cast a shadow. And so you have these narrow, more specific rights, but when you shine a light down through them, they cast a shadow, creating what they call a penumbra. Just means a shadow, but it's a fancy word, so it sounds a lot better. And then down in that shadow, you can start to see new additional rights that are there, okay? Now, it might sound like they're just making stuff up here, but at the same time, which maybe they are, but at the same time, it's an awfully reasonable way to think about judicial interpretation, right? There's a whole bunch of stuff going on. We don't know that much about it. Or it's new stuff, right? And so how are we going to take these old things and apply them to new problems? Well, okay, we're going to have to kind of cast a light through them and see what shadow is showing underneath. So it looks kind of like this, right? I'll have this a more fancy drawing later, but this is, how I used to do it on the board. And for right now, that's how I'm doing it. But, here you have a light at the top, and then you have shadow, light coming through, hitting the Constitution and amendments, and you have a penumbra, and then in that shadow, in that penumbra they largely appealed to 4 and 8, if memory serves here, but different justices kind of appealed to different ones, right? So is it so crazy? Well, no, it's not, and I think that's what you're doing no matter what kind of judicial interpretation. Because if the Constitution is not clear, or if it's a new problem, how does it apply? I feel like this is pretty much what we're doing most of the time. I'm just going to mention this one real quick. Heller versus District of Columbia. This was 2008, I believe. Scalia wrote this one. He claims to be a big originalist, but this is definitely not an originalist ruling. It just isn't. Being necessary to the security of a free state, comma, the right of the people to keep and bear arms, there should be another comma, shall not be infringed, okay? There's so much going on here, but when he says when it says the people, it's the same meaning of the people that we see at the preamble of the Constitution. We, the people of the United States, okay? It's a group declaration, okay? So what is this saying? This is fundamentally written as a group right that people have the right to practice and bear arms in a state-sanctioned militia, something like the National Guard. According to how it's written, maybe you can keep a gun at home, maybe not, right? There's lots of leeway according to how it's written as far as who runs the militia, probably a state or a city, but who runs the militia, where you get your gun from. I mean, clearly it stipulates a right to bear arms, but notice how it's linked here to what? A free state, the security of a free state. What do they mean by that? And I'm just explaining to you a bunch of history here, and go take a bunch more classes on history from the time and study some civic republicanism is what it's called, and it'll all make sense to you. But a free state is a state that has popular participation. So a republic, that's what they mean. They mean a republic. And two, is not conquered by a foreign power. So what's the intent of this right? It's so that people can prevent tyranny, whether it's internal or external, okay? It's not protecting yourself in your home. It just isn't. I'm not saying you don't have that right. I'm saying that's not how the Constitution is written, okay? That's all I'm saying. Well, Scalia decided, he used the penumbra, basically. He doesn't want to admit that, but he did. And he basically decided that, yes, that more or less you kind of do have a right to have a gun at home, kind of no matter what, right? And what this one did was it overturned a handgun ban in District of Columbia, right? So they were banning handguns. Well, I'm not even sure handguns fall under the Second Amendment. If you're concerned about fighting a war, and that's what we're talking about, yeah, I mean, handguns, I guess they're nice, but what do you really need? You actually need assault weapons. Like, in my reading, the Second Amendment justifies assault rifles way before it justifies handguns. So does it also apply to handguns? I don't know, maybe. Use your penumbra. But he wanted to make the ruling, and so he did. And he got to write that one. Okay, so I'm just going to end it here for right now. We have this other one that I will use, but I don't have it kind of broken out quite right here. So we'll finish here. I have an activity that's a companion activity that very clearly kind of gives you some playtime to sort of have fun with some of these things. Okay.